SJC-11676, Commonwealth versus Joseph Ridge.
Good morning, Your Honors. My name is Catherine Riley. I represent the defendant, Joseph Ridge. This is an appeal of the denial of the defendant's motion to correct minimus. This case raises the issue of whether when a defendant is held pre-trial simultaneously by two courts on two different charges and then pleads guilty in both courts at separate times and receives concurrent sentences, whether credit for the days he was confined pre-sentencing should be applied to his concurrent sentence in a manner that gives him some actual benefit for the days he was confined prior to the sentencing. Here, the defendant's accrued jail credit was applied to the shorter of two concurrent sentences.
Well, it was the first sentence that was imposed in 2007, right?
That's correct.
So when he's sentenced in Norfolk to 4 years in prison, he's given 253 days credit.
Correct.
And if he hadn't been sentenced to anything else thereafter, if he had no other crimes pending, he would have gotten 253 days of credit.
Correct.
The only reason that he didn't have it make a difference is that in more than a year later, in 2008, he was sentenced to another 14 or 15 years in prison to be served concurrently with the sentence that was previously imposed. This was done by plea agreement in which there was no mention made of jail credit or anything else.
Yes, that's true.
So, and I don't even know when that sentence was, it just started as of 2008. It was served concurrently, but it didn't go back to 2007, right?
Correct. It was not imposed non-proton.
So he basically got the deal that he was supposed to get, right?
Well, the 253 days also encompass 129 days, which he was held by orders of the Plymouth County on the Plymouth County Court.
Well, he was arraigned in Norfolk in June of 2006.
Correct.
Then he was arrested in September of 2006 on different Norfolk charges.
Correct.
And then he's arraigned in October of 2006 in Plymouth. So isn't he already sort of being held in connection with other things?
He's being held in connection with other things, but he's also being held with on the order of the court of Plymouth County on bail that he cannot post for the crime that he later pleads guilty to the 14
But he wasn't
to 15
going any
years.
place in the first place.
No.
Right.
No, he was not. And also, just to address the circumstances of an agreed-upon plea as factoring into the sentencing. The Commonwealth suggests in its brief that the parties to an agreed-upon plea took into consideration that the defendant would not be receiving jail credits. I believe this argument fails. In determining an appropriate sentence, a judge looks at the circumstances of the crime, the injury done to the victim, the defendant's record, but they do not look at how long a defendant has been awaiting trial or sentencing. Had the judge thought a defendant was entitled to jail credit, he would not have adjusted the sentence to take away the benefit of the accrued jail credit.
But if the judge thought that there was nothing prior, if the 2008 plea was the only plea, and he hadn't been serving any prior sentence,
Correct.
then the judge would take into account jail credit.
Yes.
Didn't here. It wasn't even discussed.
I did not order the transcripts of the plea, and that was an issue in the Commonwealth's brief. But I think actually in the regular course of business, what happens is a sentence is imposed. A call is made to the institution where the defendant is being held. A number is given of jail credit, and then that's what's awarded the defendant.
Saying the judge doesn't even deal with it.
Sometimes, most of the time, I would say no. On a regular basis, I would say it's more of the institution providing the number to the court, and then the clerk's office filling out the minimus.
Are you making a fairness argument in and of itself, or are you suggesting that the statute should be interpreted to require the jail credit to go to the longest sentence? couldn't figure out which point you were trying to make there.
Yes, I am. I'm saying if a defendant simultaneously serves pretrial time on 2 cases that he later pleads guilty to concurrent sentences, that time that was due to that sentence on the longer sentence should be credited towards the longer sentence so that he actually receives some benefit from it.
So how practically is that supposed to work? If he's sentenced in Norfolk County and nobody knows what's going to happen to the Plymouth County cases, so what is the judge supposed to do? In the second case, I mean, you know, suppose he's, I don't know, suppose that the case works out, well, I guess, take that back. In that case, it wouldn't be a problem. But it just seems to me that that's an unworkable solution, and I can't quite get my hands around the particular way in which it doesn't work. But I don't know how you practically adjust based on which sentence is longer.
I think practically, once a judge is imposing a concurrent sentence that is, in this case, substantially longer than the sentence he is serving, then he should look at the pretrial confinement that was accrued on that case and credit it to the longer of the sentences.
Even though it's already been credited to the earlier sentence, he's supposed to go back and undo that. I guess that's one way in which I'm trying to ask the practicality question.
You know, I've thought about the practicality of that, except really what happened was my client got credit for those 129 days on paper. In actuality, he was in custody from 4 to 4 in a day concurrently with his 14 to 15. So I don't believe it would be onerous to give, in some logistical fashion, to give the credit on the longer of the concurrent sentences.
When he pled guilty in Norfolk, I understand he didn't know, he knew, everybody knew of the pending Plymouth case, correct?
Yes.
So would it be fair then that you, at least consistent with what you're saying, that at that time, since you don't know what's going to happen in the Plymouth case, that in Norfolk, the credit should just be the part that was solely Norfolk's? If I understand correctly, it was a piece of this in which he was being held on both, but not all of it.
Correct.
So as not to get double credit, you could, right? You could say, well, okay, then if you want to get your 149 days on the Plymouth, then you should limit the Norfolk credit to whatever the difference is. I don't know.
Yes, I think the trial attorney had, you know, but the problem is 2 different counties, 2 different attorneys. The attorney representing him on the habitual offense out of Plymouth, which was later dropped, and then he served. I think to put that a responsibility on the defendant might not be practical. I think what I've concentrated on is what is actual credit. You know, this credit did nothing for him. It did not lessen his sentence in any way, and he was held pretrial on the Plymouth case.
Well, it did lessen his Norfolk sentence. I mean, it definitely did.
Correct, but for no benefit.
Well, it had no practical benefit, but it did lessen it.
Right, but he did not, in his eyes, it didn't. I mean, he spent every day of the 4 to 4 in a day in custody and is still in custody. I think also one more point, in dealing with incorrect release dates and getting institutions to get calculate the right dates correctly and making motions to correct minimuses, a lot of this falls on unrepresented defendants. Even Mr. Ridge in this case did not have an attorney until it was in the appeals court. I think it makes it important that the law is clear on its face and also just and logical. The idea that he was credited with these 129 days.
He does have an attorney at the time of sentencing, and doesn't it seem fair to impose on those attorneys some consideration of how these concurrent sentences will work? I mean, at the end of the day, your client wants to know, well, how much time am I going to have to serve?
Correct.
What does this concurrent mean? So he has an attorney at the time when the implications of the sentences
That's
are.
correct, but many times if he had been given credited that the institution didn't believe he was entitled to, they would have corrected his date,
Okay.
and he would have had to bring a motion to correct minimus anyway. So I think it's whether or not he's entitled to the credit, and that has to be clear.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Laurie Schulis for the Commonwealth for Plymouth County.
Can I ask you this question? At the time of sentencing in the Plymouth County case, could the judge have made the sentence nunc-pro-tunc back to the beginning of the Norfolk case?
He could have, absolutely. He
And
did
what
not.
would have been the implication?
Well,
I mean,
under...
Go ahead.
There's an unpublished case which I cite in my brief, Commonwealth v. Gaudreau, where that was the case, where it did go nunc-pro-tunc back. And the court, in that case, did not order the additional days for other reasons. But I think the analysis of the nunc-pro-tunc is important because what the sentencing judge is saying is, we want them not only to be served concurrently, but together, so the time will start from the sentence of the first case through. That didn't happen here, so the result is, and Commonwealth v. Barton, where it examines the three types of concurrent sentences, that actually is a second option. So when
So if it was nunc-pro-tunc, let's just assume the judge said, I'm going to make this nunc-pro-tunc so that it runs completely concurrently
correct.
with the Norfolk sentence, how would the jail time factor in? Would then the jail time that had been credited to the Norfolk sentence be fully credited to the Plymouth sentence as well?
I think in that case it would operate that way, and I think the defendants, if you go nunc-pro-tunc back, the dates start on the date of the Norfolk sentence. Both sentences run concurrently. The 129 days gets credited, but they essentially get credit on both cases because they start the same day. So it's not an aggregate of 258 days, but you're basically taking that 15 months going backwards to the start of the Norfolk case. So you're actually getting a benefit of 15 months on the Plymouth case with a nunc-pro-tunc order. That wasn't done here, and so as in any order, once the sentencing judge orders it, unless there's a nunc-pro-tunc order or a specific date when the sentence is to begin, it begins on that date.
I'm getting lost here. So let's take Norfolk. He's sentenced to what, 4 to 4 in a day or something?
Correct.
All right. And at that point, he was given credit for the entire time spent in pretrial custody,
Correct.
regardless of what he was being held on.
Correct.
Right, it's the entire 200 and something days?
53 days.
50 days. All right, so now we have Plymouth nunc-pro-tunc, let's assume. How does the 250-some days get parsed out, or what?
Well, what happens is it becomes effective on the date of the Norfolk sentence.
Okay,
The Plymouth case backtracks 15 months to the start of the Norfolk sentence.
Right.
So he receives the 129 days jail credit on Plymouth plus his Norfolk's pre-sentencing.
I thought
But he got the 129 already.
yeah. He got
On
the
the
250, he got the 250-something.
Well, I don't think jail credit becomes relevant on the Plymouth case at that time because you're nunc-pro-tunc going back 15 months. So you're starting your Plymouth sentence 15 months prior to the
Correct.
actual sentence date.
So he's getting a better deal that way, right?
He would if the judge had ordered it, but he did get a substantial benefit of his plea agreement. He got a concurrent sentence, and he got a dismissal of a habitual offender count, which carried a potential life sentence. That was a plea bargain that he and his attorney orchestrated with the Commonwealth that the sentencing judge in Plymouth adopted. There was no talk about pretrial credit on the docket or on the MIT. The defendant has not put forth a transcript of what occurred at the plea hearing, so the records he presented to the motion judge are based on that docket and the MIT, and they're both silences to that credit, and I don't think that this court or the defendant can read into that the judge or the parties intended that the defendant received any more credit. That was part of the agreed-upon recommendation. They all agreed to it. The judge was aware of the prior sentence. The defendant certainly was aware of the prior sentence, as was the Commonwealth. This was agreed-upon plea. They agreed that it was going to be concurrent. They agreed the length of the term. There was no mention of any jail credits, and it's not till 5 years later that the defendant comes back and asks for this, and that delay should be held against the defendant where there is not a transcript presented and not other credible and persuasive evidence that that document does not stand on its face for saying no jail credit was intended.
If he had raised it in Plymouth at the time, I get your 5 years point, but if counsel at that time had raised it and said, you know, he served 149 days waiting trial, and we want it off of here, and the Commonwealth would have said, but he got it off of the other one, there could have been an adjustment at that time, right? Maybe?
At the day of sentencing? Or
Yeah, a
after?
day of sentencing in
sentencing.
Plymouth. In Plymouth.
In Plymouth, if that was an issue that was not negotiated as part of the plea agreement, which was considered by the parties,
but
if he had raised it before the sentencing judge, absolutely, the sentencing judge could have, and
could have given him some
the transcript
credit.
may have borne that out, but the defendant does not put that transcript forward. The defendant has decided to present this case as it is on the docket and on the MIT, and based on the docket and the MIT, we don't see any conversation about that.
Didn't the judge say?
The
I thought
motion
the judge
judge
actually
laid-
rejected it. Oh, that was
Motion
that was
judge
in the
5 years
5 years later.
5 years later, the motion judge said, twice took a look at this case and said he got the benefit of an agreed-upon plea and the reduced charges on the habitual offender count. And in his, his language was fairness did not dictate a different result, that the defendant was entitled. And I think where the defendant received the 129 days credit on the Norfolk case, he's not entitled to double credit. He would be getting an aggregate of 258 days on pretrial sentencing on an agreed-upon plea, which is significant. I'm assuming.
But you would agree that if it had been, I'm just trying to get to, if he had raised it, he might have gotten something.
Well, it would have been examined by the sentencing judge, and it would have been a discussion before the sentencing judge with
But the
everybody
judge could have.
present.
The judge would have had power to give him days.
Absolutely. The judge would have had power to consider, and he could have had the power to say, no, that's not part of the agreed plea before me, so I'm going to deny that you received it in Norfolk. He could have considered it.
Could you explain again, I thought he had gotten 253 days of credit in connection with the Norfolk
So he was held in Norfolk prior to Plymouth. So the time that we're talking about, the 129 days, is he was serving pretrial detention on both cases only. The remainder of that 253 days was only applicable to Norfolk, and the defendant isn't seeking that time. That's only applicable to Norfolk. So that's the difference there.
He didn't post his bail on the Norfolk charge?
I believe
And then his bail was revoked on November 1 of 06.
on the Norfolk charge, he was held without bail on Norfolk prior to his arraignment in Wareham District Court on the Plymouth case. And then on November 1, I believe you're right, his Norfolk bail was revoked.
So is that because had he posted bail?
He defaulted on the Norfolk case on May of 06.
Yeah, you don't default by virtue of having been in jail because the sheriff
So
didn't
he must
take
have
you.
been released at some point.
So he must have been released.
I don't have that procedural history before me. He was released, actually, when he was arrested by the Falmouth police in September of 06. He had already committed, I believe, the Norfolk offense, and he was out on bail, and he was arrested in Falmouth on separate charges.
Yeah, but on October 20th of 06, he was arrested for armed robbery in Wareham District Court and held on bail. That matter then became the Plymouth indictment.
He actually wasn't arrested. That he was arraigned that day on the Wareham case on October 20th, 2006.
Yeah, and he was held continuously on that charge, which morphed into the Plymouth indictment. He was held continuously since October 20th of 06.
On that, in other cases, he also had a Newton case and a Falmouth case, and so he had other cases open at that time. So he was held on Plymouth from October 20th, 2006 until February 26, 2007, when he pleads guilty in his Norfolk case. So I see your question is, was he released from the Norfolk case?
Yeah.
During that time period? He may have been, but he might have been held on those other cases as well, and there hasn't been a claim that was only attributed to Plymouth. Before my time is up, I would just like urge this court to look at the Commonwealth v. Barton when it talks about the three different types of concurrent sentences. This case is more like the third type. In Commonwealth v. Blakey, it talks about this as well, and the unpublished cases that I cite in my brief as well regarding how to look at concurrent sentences and why just placing just using as a measure the higher sentence, and I think Justice Hines was getting to this point, becomes impractical, especially when the later sentence is longer or shorter and there's no way of telling when the first sentence is imposed. Is a case-by-case basis. Under Shalifo, we look at this under a case-by-case basis. Here, there was an agreed-upon plea, but beyond this case, I don't think it's fair to assume that when we have a concurrent sentence, that we should assume that pretrial credit should be applied to both cases where the sentencing judge has specifically not ordered it.
Okay, thank you.
Thank you.